All right. So we'll see this remaining part relating to written statements. So written statement provisions are given in order 8, and there along with written statement we have set off as well as counterclaim. So this entire order 8, it is mainly having 3 different sections or 3 different parts. One is talking about the general rules, just like how we had for pleading plus plaint, some general rules that we need to follow. Same ways for written statement also, there are some general rules that need to be followed. Then it talks about set off and then counterclaim. So set off and counterclaim provisions are given in between. And here we have rule 1 to 5, 7 to 10. These are relating to the general rules relating to written statement. So these are all the rules which we have. Now first rule 1. As such, written statement has not been defined, but then it gives some idea on what other things that needs to be taken care of or what all rules to be followed. So first rule talks about written statement. It mentions the time frame within which written statement has to be submitted. So from the date when summons is served, within 30 days, the defendant should write his grounds or his defenses and submit the written statement before the court. But sometimes it may happen that within this prescribed time, he is not able to submit the written statement. Within 30 days, he is not able to submit the written statement. So if the defendant fails, then he may be allowed an extension. He may be allowed to file the written statement on such other day as may be specified by court. So if there are reasons that he has provided, court may extend that duration and court may assign some other date within which he need to submit his written statement, but then that extension shall not be later than 90 days from the date of service of summons. As in first, initially it should be done within 1 month, then an additional 2 months extension might be provided by the court. And it would also record the reasons why that extension was been given to the defendant to provide his defense or to submit the written statement. In rule 1, there are actually 2 proviso which we have. First one is this general one. Second one, another we have, which is added by Commercial Courts Act. So after 20 days, his right would be like forfeited. He would again not have the right. Defendant's right to submit the written statement or file the written statement, that would again be forfeited. So there was one case as well, SCG Contracts India Private Limited. In this case, Supreme Court observed that this proviso which is added in CPC, so whatever courts it is mandatory and no written statement can be taken beyond this date. So this time limit, whatever is provided, 120 days, 90 days and 30 days, this provision is mandatory, and after that it would not be like on the discretion of court that court can make any extensions on that point in time. So the defendant shall forfeit his right. Again, after that, this time limit cannot be extended at the discretion of court as well. So in this case, basically High Court of Delhi, I guess, had extended the time duration. But then Supreme Court said that this rule, whatever is provided here, judgment of High Court, wherein the defendant was allowed that you can submit your written statement even after 120 days. But then Supreme Court said that this cannot, there cannot be an extension from the court side because this time limit is fixed and that only would be applicable. So when High Court ordered that you can file the written statement, that order was taken off the record. This written statement which was submitted, that was not accepted basically. Right, so that was rule 1. Next is rule 1A, which is duty of defendant to produce documents upon which relief is claimed or relied upon by him. Now, in case of plaint as well, when the plaintiff was submitting the plaint, there might be some documents based on which he is relying his entire claim. there it was necessary for him to submit those documents as well. He had to mention a list of those documents, submit a copy along with another copy with it. The document plus a copy along with the plaint had to be submitted. Same rule would be followed in case of written statement also. If the defendant is relying his claim based on such document or any such records, then in such case, it is mandatory for the defendant as well that he need to submit copy of that. So if the defendant bases his defense on some kind of document or his set of counterclaim, it is based on any specific document that need to be submitted along with a copy of it. So the same provision is there in case of plaint also. Exactly same thing is here for written statement as well. Then we have rule 2, which is new facts must be specifically pleaded. The defendant must raise by his pleading all matters which show the suit is not maintainable. Any sort of transaction, if the plaintiff has made any claims that I have these claims against this other person, against the defendant, and defendant wants to say that maybe the suit is not maintainable, maybe it's beyond the limitation period, transaction was either voidable and the defendant has not decided to proceed with it, or maybe the transaction was void, or maybe it is based on any of these grounds like fraud, limitation, release, payment, performance, facts showing illegality. If he has any grounds to prove that, also he needs to mention there. New facts must be specially pleaded. It should not happen that at a later stage he is saying that this transaction is void or something. It should be mentioned in the written statement itself.
New facts meaning what is not mentioned in the plaint, right, madam?
Yes, not mentioned in the plaint.
Okay.
So if plaintiff has not said that maybe defendant's consent was taken by way of fraud and defendant wants to mention that as a defense, then he needs to mention it in the written statement in itself. Maybe that the transaction itself is void because of that. Then denial to be specific. If there are multiple points that he has mentioned in his plaint, maybe there are 3-4 situations that has happened and 3-4 claims are there, the defendant needs to deny specifically whatever he wants to deny. He specifically need to deny to those points. Might be if a person has said that deal specifically with each such allegations, there might be a situation wherein it talks about 3-4 different situations, 3-4 different claims. Each of that he needs to specifically deny, only then the denial would be considered. So it shall not be sufficient for a defendant that in his written statement he generally denies the grounds which are alleged by the plaintiff, but he should specifically talk about all of it. That's why it's also necessary that plaintiff again mentions it clearly in different paragraphs, different claims, so that defendant also can make out that there are 5-6 different claims in this particular plaint. Then evasive denial, where a defendant denies all allegations of fact in the plaint, he must not do so evasively but answer the point of substance. Thus, if it is alleged that he received a certain sum of money, it is not just sufficient that he just denies that I have not received that amount. He should also mention that he has not received that certain sum what is mentioned, or any part of that also, whatever it is. Specifically he need to mention that not just this amount, any part thereof, or else set out how much he received that. Or if he has received certain amount, then he would mention out of this total amount I have just received this much, or maybe I have not received anything out of this entire amount, not even any part of that entire claim also. Specific denial. Every allegation of fact in plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the defendant shall be taken to be admitted. So it's very much necessary that whatever claims are there in the plaint, all those that the defendant do not want to admit, he should specifically deny to all those points. So if they are not specifically denied, or might be something maybe very much implied in itself, so it is not implied, then he needs to specifically deny to those points also. Like if he is saying that I have not received this entire sum nor any part of it, that might imply that, okay, fine, this person is liable to pay me the amount or the interest also. I have not received the interest also. Like that, some things might be implied. That if I have not received any part of the amount, as in I have also not received the interest. Sometimes something may be implied. Otherwise, everything needs to be specifically denied by the person. If it is not denied, it would be assumed that he has admitted to those points, whatever is not been denied by him. Where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of facts contained in the plaint, except as against a person under a disability, but the court may in its discretion require any such fact to be proved. So the person, if he fails to submit the pleading within his time, or even after extensions given, he is not he failed to submit the written statement, court may pronounce a judgment based on the information available. So specific denial would be required for all the points, whatever is mentioned in the plaint by the plaintiff. Now, those were like the general rules. Again, from this part we have, from 7 to 10, we have some general rules. Then in between, there are provisions related to set off and counterclaim. So rule 6 is particulars of set off to be given in written statement. So there are two things basically mentioned, set off as well as counterclaim. Set off is given in rule 6, just one provision. In case of counterclaim, we have in case of counterclaim, it is mentioned from 6A to 6G of the legislation. So set off is where in a suit for recovery of money, the defendant claims to set off against the plaintiff's demand any ascertained sum of money which is legally recoverable. Now it is important that maybe one person is claiming from the another that I am supposed to maybe get 20,000 rupees. If A claims that I'm supposed to get 20,000 rupees from B, which is an ascertained sum. So A in his plaint has mentioned that I'm supposed to get 20,000 rupees from B, and he files a plaint for that. When B gets summons for it and he has the time limit, 30 days time limit to submit his written statement, in that written statement itself, he may mention that, in fact, I'm also supposed to get 15,000 rupees from A. So yes, A is right, I need to pay him 20,000 rupees, but I also should get 15,000 rupees from A. So this will be nothing but set off, that you can adjust this amount with this one. Like I also have a claim against the person. And what kind of claim it is? It is an ascertained sum of money. The amount is fixed. It's not like some accounts need to be settled or something. It is a fixed amount that is recoverable from this person. And when this amount is mentioned in the same written statement, it should not exceed the pecuniary limits of the court. It should not go beyond that amount. And the person may mention that in fact, I also should be getting, I also am entitled to recover some money, and this is legally recoverable. It's not like it is barred by limitation or something. I have a valid reason to claim this amount from the other person. And both the parties fill the same character as they fill the plaintiff suit. So it has to be, if they both are like individual persons, they are filing the case, it has to be in that same way. Or if they are maybe as an agent of some partnership, they should be in that same capacity only. So it should be in the same character that they are filing the case. The defendant may at the first hearing of the suit, but not afterwards, unless permitted by court, presents a written statement containing particulars of the debt which he has sought to be set off. So he would mention details that this is how 15,000 rupees I can also recover from the other person. Okay, so these are the things that are necessary, that it should not exceed pecuniary jurisdiction of court. It should be an ascertained sum of money only, and it should be against the same person that he has his valid claim. And when B mentions that I also am entitled to receive 15,000 rupees from the other person, maybe there is a decree from the court that I have in my favor and against A. So the effect of set off would be that written statement shall have the same effect as a plaint in a cross suit. In case of cross suit, how written statement would be considered as a plaint in itself, same effect this also would have, so as to enable the court to pronounce a final judgment in respect of both the original claim and of the set off. Based on both the things, court would finally pronounce a judgment wherein both the parties' claims or their demands are being satisfied.
Madam?
Yes.
Hello?
Yes.
Madam, see in this order 8 of rule 2, new facts must be specifically pleaded. Is that not similar to, so same thing can be, the set off as a new factor is the same thing as that, isn't it?
The defendant must raise in his pleading all the matters which show the suit is not voidable. Set off is as in he is making some additional claim that yes, this person is validly claiming 20,000, but I also have a decree wherein I am entitled to receive 15,000. That is sort of claim that I have, that I also am entitled to something. But this
class 2 and this 6 is different.
This is mainly, it might be like a ground of defense. Okay, it might be like a ground of defense, or you are saying that this transaction itself is void or voidable. You are simply denying that transaction is void, so I don't need to pay 20,000 rupees. But in this case, you are like, I'm also entitled to receive something.
So set off doesn't come under the clause 2.
No, set off would be only 6, rule 6.
Now, on what grounds he will ask, Madam, set off? He can't simply just give a statement that he owes some money. He has to go show some proof, right?
Yes, he has to go through some proof.
He can't simply say, okay, he owes me something, then the court take it.
Here a provision is also there, in fact, not exceeding the defendant may at first hearing of the suit, but not afterwards unless permitted by court, present a written statement containing the particulars of that. He would produce those. It might happen that previously itself there is some decree that court has provided, like some other courts.
Yeah, so that is only subject to the decree is having.
Yes.
Just like that.
Yes, yes.
Yeah, okay. And this guy A has not paid, he can claim that decree from A when A files a suit to B.
Yes.
Okay.
So it might be decree, or it may be if the amount is certain that this is only the amount, it is less than this person. Like here, he is claiming 20,000, he is claiming 15,000. 15,000 is lesser and it is ascertained. In that case also it would happen. The party can prove that these are the documents I have, and this person has, like I have this valid and a legal claim to be made from this person. In that case also it might be like entertained by the court. If it is not exceeding pecuniary jurisdiction, if it is legal claim, a certain sum of money is there that he can mention.
Okay.
Just he need to mention the documents and stuff, that particulars of the debt, that this is the proof I have that this person has taken 15,000 rupees from me. Like that also he can do.
Now in this set of cases, If
Yes.
the plaintiff does not come, the case gets dismissed.
No, even if the plaintiff is not coming, court would look into the matter. But yes, because this is like a lesser amount, there is no claim as such. If plaintiff is not coming, like B is supposed to make the payment. So there is no point as such for court to entertain. But in case of counterclaim, the case would anyways be heard, even if the plaintiff is not coming, not appearing. Whatever happens to the original case, the counterclaim would anyways be heard just like a normal case only.
So only in set-off case, it will be not heard. Okay.
Yes, yes. So in case of counterclaim, these provisions were later on added in 1976. So for counterclaim, it might happen that it's not just maybe an ascertain sum of money, but there is some cause of action. So there is a cause of action whereby the person has some claims against the plaintiff also that he can mention over here. That will be counterclaim by the defendant. So now this cause of action may take place at any point in time. It may happen.
Come again, counterclaim, ma'am. So set-off is adjusting his money. Counterclaim, can you?
Yeah, counterclaim is not, it might not be like an ascertain sum of money, but it is like cause of action. You have a cause of action, you have a valid ground to file a case against the plaintiff. But might be you are not filing the case, or you are about to file the case, and in the meanwhile, you receive the summons. So at that point in time, rather than filing two cases to avoid multiplicity, in the same written statement, you may say that in fact, this is the claim that I have. It may be any sort of cause of action.
But in any case, he will mention his claim in the written statement. Why this specific counterclaim, madam?
Who will mention?
No, in any case, written statement, any new facts he will say. Whatever is mentioned is not okay. He has to give me something. All that he will mention. So it's already mentioned. It's already provision is there. Why specifically this counterclaim clause is there? Because
see, I might say that okay, fine. Like set off was fine. That okay, this person is claiming 20,000, but he should be giving me 15,000. That might happen. Plus another one is there that rule 2 that may also happen, wherein I can say that no, this entire transaction itself was void. But in case of counterclaim, it may be like an entirely, it might not be two related cause of action, it might be another cause of action as well. It is in order to avoid basically multiplicity of cases wherein parties don't file 2-3 cases. If similar some cause of action is taking place during this time of filing the written statement, that same thing you can bring there and just add it in the same provision only. That is the main reason basically.
Just give me an example, madam, for that.
Counterclaim, yes. Take for example, one person files a case against another where he says that maybe I am, okay, there is like a lease agreement between two persons and A is the owner of the property. So A is the owner of property. There is a lease agreement with B. Now, based on the terms and conditions of the lease agreement is already over and all the transactions, everything is clear. Now, technically, B should vacate the plot of land. So based on the agreement, B should vacate the plot of land. But what B is doing is he is not vacating the plot of land. He is staying there. So A sometimes comes around the property, he walks or something he does. Now B, what he is doing is he goes to the court and he rather files a case seeking injunction that A should not be allowed to enter this certain property. A should be restricted from entering this property, and for that he has sought maybe injunction. In that case, A can say that how come he is asking injunction? I am the owner of this property. So in counterclaim, A will say that based on this certain agreement, already terms and conditions, agreement is already over. So he would ask the court that you should ask this person to leave this plot of land, right? Like this recapturing of land, there is one relief which is mentioned under specific relief. Owner might say that I want to recapture my plot of land because I am the owner of it. Agreement is already over. So in such a case, A do not need to go and file maybe another case. He can mention under the same thing itself. So this would be like a defense which they are using in case of set off, that I'm not bound to pay 20,000 rupees, but just 5,000 rupees. That is like a defense, but this is like taking action against the other person altogether, right? This person was enjoying the property. He was living there peacefully, but now what would happen because of the this counter claim, he might be asked by the court that you vacate the plot of land. So in counter claim, the claims might be something which should in fact put the plaintiff only at risk. Like he was claiming something, but on the other hand, court asked him only to pay something, or some order came against him. It might happen like that also in case of counter claim.
Okay.
So in case of counter claim, main idea is to prevent multiplicity of cases, that a cause of action might take place at any point in time. It may be before or after filing of the suit. It might happen that before the this person who was living in that particular plot of land, before he filed the plaint, before he instituted the suit, before that only cause of action had taken place. That agreement was already over only. It might happen before the defendant has delivered his defense, before the owner submits his written statement. That point in time also it might happen. It may happen before the time limit for delivering of the defense has expired. Before that 90 days, 120 days, 30 days time frame also it might have happened. So if it has happened before that point in time where you still have the option of adding those things in your written statement, then you should make it happen in the same suit only, rather than creating multiplicity of cases. Again, for counterclaim also, it should not exceed the pecuniary jurisdiction of the court, and counterclaim is in nature, whether such counterclaim is nature of claim for damages or not. It does not matter what kind of claim it is. Like in this case, owner was basically seeking for recapturing of property, that I am the owner, I should be entitled to recapture the property, and this person should be asked to vacate the plot of land. So that also would be allowed in case of counterclaim. In case of counterclaim, it shall have the effect just like a cross suit, as if this person has filed a case against the defendant has filed a case against the plaintiff, and court would pronounce a final judgment in same suit, both the original as well as cross suit. Court would pass a judgment, final judgment, court will pass. The plaintiff shall be at liberty to file written statement in answer to counter claim of the defendant within such period as may be fixed by court. Because again, he is making some allegations, the plaintiff also would be given time that you again reply to the written statement, this counter claim whichever is placed. And counter claim shall be treated just like a plaint, and it would have the same rules and regulations governing. Like if there are multiple claims, it has to be mentioned separately. All the rules of plaint would be applicable over here as well. So in case of counter claim, it might happen that some other related civil matter also is taking place. The person can mention that as well. Okay, so counter claim to be stated when the defendant seeks to rely upon any ground as supporting a right of counter claim, he shall in his written statement state specifically that he does so by way of counter claim. So he would mention that thing as well. If the defendant seeks to rely upon any ground as to supporting a right of counter claim, he shall in his written statement itself specify that he does so by way of counterclaim, that would be mentioned by him. Exclusion of counterclaim, where the defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but in an independent suit, the plaintiff may at any time before issues are settled in relation to the counterclaim apply to the court for an order that such counterclaim may be excluded, and the court may, on hearing such application, make such order. If the plaintiff who had initially filed the case, if he says that the counterclaim is based on some separate grounds, it is not that much related to the matter, it should be heard separately, he can apply to the court for that, and court will pass an order based on it. If court feels that it can be decided in the same case itself, court would do that. Otherwise, court may say that it would be treated like a separate case as well. Exclusion of counterclaim. The plaintiff may apply for that, and court would finally decide whether to exclude the counterclaim, treat it like a separate case, or just in the same case they can deal with it. Now, there might be cases wherein plaintiff had filed a case, like might be in this one, plaintiff approached the court and sought an injunction order, but when the real owner filed a case for recapturing of property, maybe plaintiff may want to put a stay in that, plaintiff may discontinue, or the case might get dismissed. But that does not matter. Whatever happened to the original suit that was filed, counterclaim would proceed just like in its normal way, because counterclaim is treated like as a separate suit in itself. So that counterclaim would go on in its normal way only. It is nothing but like a separate suit only we would treat, but in all, like at once only it has been dealt with. So if a person is filing counterclaim, after that anything happens to the original suit, that would not affect the counterclaim. It would be decided in its normal way only. Default of plaintiff to reply to counterclaim. If the plaintiff makes default in putting in a reply to the counterclaim made by defendant, the court may pronounce judgment against the plaintiff in relation to counterclaim made against him, and make such order in relation to counterclaim as he thinks fit. Just like how it applies for the original case, that plaintiff filed a case, defendant was not submitting the written statement even after court gave him extensions and everything, court can take a decision based on the information available. Same ways for counterclaim also, if the plaintiff is not replying to the counterclaim, whatever is mentioned in the written statement, in that case, court can pass a decision based on the information available. Whatever they think fit, they can pass an order based on that. Relief to defendant where counterclaim succeeds. Wherein any suit or set-off or counterclaim is established as a defense against plaintiff's claim, and any balance is found due to the plaintiff or the defendant, as the case may be, the court may give judgment to the party entitled to such balance. So court would look into the matter and accordingly decide the case. Rule relating to written statements to apply. The rules relating to written statement by a defendant shall apply to a written statement filed in answer to counterclaim. Basically, if there is a counterclaim, it would be treated like a normal, how the rules of plaintiff are there, those would be applicable. And in that case, original plaintiff will have to submit a written statement as a response to the counterclaim. So those same provisions would apply based on what they are writing in it. If it is counterclaim, rules of plaintiff would be applicable. If original plaintiff is replying to the counterclaim, same again, rules of written statement would be applicable to him as well. Next one is defense or set off found upon separate grounds. where the defendant relies upon several distinct grounds of defense or set of founded upon separate and distinct facts, then they shall be stated as far as may be separately and distinctly. Same like in case of plaint, the person would mention all his claims separately and distinctly. Same ways, whatever may be the defense, whatever may be the set of counterclaim, it also has to be mentioned separately and distinctly by the person. New ground of defense. Any ground of defense which has arisen after institution of suit or presentation of a written statement claiming a set of or counterclaim may be raised by defendant or plaintiff in his written statement only. Then Rule 9 is relating to subsequent pleading. No pleading subsequent to written statement of a defendant other than by way of defense to set off or counter claim shall be presented except like court's permission would be taken. If court thinks fit, court would mention a time frame, within that time frame it may be submitted. So no pleading subsequent to written statement of defendant. But if defendant has put certain set off or some counter claims and it is time for plaintiff to reply, then court may give permission that within this duration you need to reply, and plaintiff may provide his response to those counter claims or set off as well. Okay, so subsequent pleading, the court may ask that you respond to this counter claim or set off, and based on that the person may be given time limit within which he would need to respond to the counter claim and set off. Now, procedure when party fails to present written statement called for by court, where any party from whom a written statement is required fails to present the same within the time permitted or fixed by court as the case may be. It might happen that he is the original defendant or he is the original plaintiff, whoever was required to submit a written statement, he fails to submit it within the time prescribed. So the court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit, or on pronouncement of such judgment, a decree shall be drawn up, provided further that no court shall make an order to extend the time provided under Rule 1 of this court for filing of the written statement. So if the person is failing to submit the written statement, whether he is the original plaintiff or original defendant, if court has required him to submit it, he has failed, then based on the information available or maybe against him, court would pass a judgment and decide the case. Okay, then there is this 4 points on the differences between set off and counterclaim. Okay. So these are the provisions relating to written statement, set off and counterclaim. For written statement, rules 1 to 5, 7 to 10, talking about the general rules relating to written statement. For set off, just one rule, rule 6. For counterclaim, rule 6A to 6G of CPC. So time limit is mentioned in rule 1. From institution of suit, when the plaintiff has been presented, defendant would be served summons, and within 30 days he need to submit his written statement. That may again be extended by court for 90 or 120 days, and he needs to submit it within that time frame only. If he is relying on any documents, those documents also need to be submitted, just like plaintiff would submit in case of submitting of the plaintiff, how he needs to submit all those documents by providing a list. Same ways, defendant also needs to do it if he is relying on that for the purpose of defense. If there are any new facts that is happening, that needs to be specifically pleaded, that maybe this transaction is void in itself, so I'm not bound to pay and other things. It needs to be specifically pleaded by the party. whatever points are there in the plaint, if the defendant wants to deny to anything, it needs to be specifically denied. Otherwise, it will be assumed that he has accepted the points if it is specifically not denied by the party. So allegations, he needs to deny it properly, and it like point wise, he need to deny to whatever is being mentioned. It has to be very specific. It's not that I have not received the amount, whatever is mentioned in the plaint. He can also mention that I have not received this entire amount plus any installments of it. Properly, it needs to be mentioned by the party. So any sort of allegations, he will deny it. Otherwise, it would be considered as admitted by the person. And if the defendant has not, where the defendant has not filed a pleading, it shall be lawful. If defendant fails to submit the written statement, court may pass a judgment based on the grounds or based on the information which is available to them. Rule 6 talks about set off, wherein person may mention what are the grounds or based on which, like legally ascertainable sum of money, if it is recoverable, he would mention that as well. Then we have counterclaim from 6A to 6G, and then from 7 to 10, again, the general rules relating to written statement. So these are the provisions on written statement, order 8 of CPC. After that, one more part is there from Unit 2, that is parties to the suit. Order 1, joinder, misjoinder. From there also, most of the times short notes are being given from Unit 2, joinder, misjoinder from that part. Okay. So fine, and I will share this document and we'll continue with parties to the suit in the next class. Okay.
Okay, thank you.